Welcome to Within the Frame, where we bring the most pressing issues across the globe into focus. I'm Kim Mok-yeon. Earlier this month, more than 300 Korean workers were detained at a U.S. battery plant site in Georgia under disputed visa rules before being sent home on a chartered flight 8 days later. The incident has sparked anger in Korea, raised questions about America's treatment of foreign specialists, and cast doubt over billions in planned Korean investment in the United States. Washington has expressed regret and promised reforms, but uncertainty still remains. Tonight, we ask, what impact will this crisis have on future projects, and what concrete steps are needed to make sure such a situation never happens again? For answers to this, we are joined in the studio by attorney An Junseong. A big welcome.
Thank you.
And also joining us online is Daniel Connolly, Associate Professor of International Relations at Hankuk University of Foreign Studies. Good to see you.
Thank you for inviting me.
So let's start a discussion with Attorney An. So with the general Georgia incident, of course, what basic legal problems do you see in how the detentions have been carried out?
It's a very interesting question because when I conduct some research on issues, and very interesting issues came up. Actually, first of all, the ICE, that have two options and to conduct arrest and the detention. And first of all, they can use their own discretions. It means that called like civil warrant or the administrative warrant to arrest any illegal alien in the United States. And in that case, they can arrest someone, right, and then illegal alien without any judicial court order or court warrant. However, they're only allowed to arrest, but they cannot conduct a search and seizure on the premises. So, however, if they want to conduct a search and seizure, they have to get the court search and arrest warrant, approved by the judge. And what the problem is, the difference is that if you want to apply for the court warrant, you need to get to higher legal standard, we call probable cause standard. So it means that the judge have to believe that a certain crime has been committed by a certain person in that situation. So that's a higher standard also. But once they get a court warrant, they can search and seizure premises, and they can do the further things. But however, if you look at the situation happened on the Georgian case, there was allegedly 475 arrestees, right? So according to the press, there's 4 individuals was named under the criminal warrant, right? Court warrant, and then the rest 471 was not listed as the target individual. So in the case, it's very interesting because in terms of technical issue, and the criminal warrant allowed ICE conduct search and seizure on the premises, the Hyundai, the battery, the factories. And then once they get into premises, they can use their own discretion, their authority to have a further arrest on the rest 471, and technically because they have their authority to do so without court order. So that's very interesting because I think they prepare for a long time, Georgian authorities, and as they claim on the TV and media, right? They've been prepared a lot, and then they thought about the legal issues, that how can you dance around the legal issues, that they use the criminal warrant to get into the premise, and once they get in there, they use their civil warrant to arrest the rest of them. So that's the very technical issue. Also, in that respect, there's many issues about is there any criminal or constitutional violation of in relation to the recent arrest happened in Georgia. But technically speaking, it's very important to note that the constitutional protection against the criminal abuse or system is most likely applied to the criminal cases. It means that they have to be criminal violation or crime, but but based on the U.S. constitutional cases, U.S. criminal cases and case law, and the court look at this situation as the immigration enforcement as the civil enforcement, not a criminal enforcement, so that the technically speaking, as of today, under the U.S. law, and that any kind of U.S. constitutional protection will not be applied to the detention cases under the immigration cases. So that's a little bit different from what we hear from the Korean media. So.
Right. So this means that in legal terms, there was no violation. Did I get it right?
To apply to the other Miranda rights, for example, should be applied. It have to be the criminal case, means that someone have to be, violate the criminal law, so kill someone or steal something, right? And then you get into criminal trials, criminal procedure to protect himself. So Miranda means that it's a prohibition against self-incrimination. So anything I said outside the court can be used against me in the court, right? But in the detention case, for Georgian case, is that it's not about the criminal case. It's about a civil case related to the immigration enforcement issue. So more like a deportation issue. So when you get the final verdict for the deportation case, it's not about guilty or not guilty of a certain crime charge. It's whether that someone will be deported or not, right? So that's how the U.S. court look at the situation at this moment. This is quite different from what we receive from the Korean media.
Mm-hmm. Right. Thank you for the clarification. Now, from a broader perspective, with more than hundreds of Korean workers detained at this flagship U.S. project, Professor Conley, what message does this send to allies about America's reliability under President Trump's manufacturing agenda?
Well, I think that's the problem, right? President Lee Jae-myung called the raid bewildering, but unfortunately it wasn't. This raid is an example of the new America. This heavy-handed treatment of U.S. allies, human rights violations by ICE of allied citizens. This is becoming the norm these days, and I don't think we can view this raid as like a technical mistake or a misunderstanding. Fundamentally, the U.S. is becoming much more coercive towards foreigners, both domestically and internationally. And this raid is taking part in the backdrop of negotiations over a tariff deal. The U.S. Commerce Secretary Howard Lutnick said just recently, for Korea, the Koreans either have to accept that tariff deal or pay the tariffs, black and white, pay the tariffs or accept the deal. And I think South Korea and many other American allies are slowly really realizing that these perceptions of a special relationship with the United States is not shared by U.S. counterparts. And in today's era, when America says America first, they literally mean America first. And the reliability of America, I think, is quite rightfully called into question.
Right. So it seems the situation is making allies question the importance and the significance of the relationship. Now, let's also touch upon the legal side again. So some workers say that they actually signed voluntary departure papers under pressure, not fully understanding it. Attorney, how could those signatures be challenged later if they were not, truly voluntary?
I guess before we answer the question, I guess if someone like to challenge whatever the writing, whatever they sign agreement in the past, I guess that's the case. In this case, immigration case, the civil case, means that someone who signed a contract under the pressure and bring action against U.S. government, I guess, we are saying for the U.S. government. And so, however, that if anyone to make argument, challenging the legal system, and you have to get proof you have a standing. You know what I mean? The constitutional requirement for the U.S., United States, you have to get, am I allowed to bring that kind of suit? So it's little technical things that if you're illegal alien, undocumented alien, right? Can they have a legal right, constitutional right to make the same constitutional right like the United States, U.S. citizens, right? That's a little bit technical issue, and I'm sure there's kind of a debatable on depends on which side you are. But however, the problem is that look at this one. I just what Professor Conley said. I think I totally agree with the professor because I'm looking at new America, new norm with the new America. Also, I don't think there's a mistake. It's carefully coordinated attack or raid, right, on the industry. I don't think it's, but my concern is that it won't be the last one. There could be the second one happen, maybe tomorrow. I won't be surprised something happen. And even the same day on the raid on the Hyundai battery, factory, there's several raid in the different states, Washington D.C. and Chicago, and several cities at the same time. And it's not like I think this question, you have to look at the legally different perspective, perhaps new Rome with the new America. Because you think that U.S. will protect your civil right, your human right, You have to think again because that now U.S. changed actually, and then even that I looked it up, I was very surprised to find that last Monday, last Monday on September 8, 2025, there was a new U.S. Constitutional Court case, which is a landmark case, basically reversing, U.S. history against racial profiling. Basically, what court said that the ICE agent, right, when they were without even criminal warrant, they can stop any person based on their gender or nationality or even language. They can stop person and ask them whether you're illegal alien or not. So that's the constitutional case now. So I guess I was very surprised because that when I was in law school, we were talking about racial profiling is bad, really the last thing happening. But now the U.S. Constitutional Court reversed it after 20, maybe 30 years after the case. So that means that even after Trump is gone, the US Supreme Court case will be stayed for a long time, actually. So that's really concerning that it's not only the Trump himself, it's not only the White House or administration or ICE, even the judicial branch changed their position on that, gender issue or racial issue and a lot of social issues, including immigration issues. That's very concerning. So I guess that voluntary signing paper, one thing, or it's more like the person who tries to make an argument. But But however, if you want to make argument, you have to base on certain other legal basis. Solely based on the immigration case, I don't think the person have a standing to bring action. So in most cases, in the immigration case, they have related a crime or related something else, something that based on a certain separate crime, or they make argument during their process, in criminal procedure, but some sort of person in illegal immigrant had violated their constitutional right. But by itself, the immigration enforcement itself is the U.S. court looking at it as a civil matter, purely civil matter, which means that there's a lot of restriction will not be applied that the many immigration cases.
Mm-hmm. So it will depend on your status in your stay. Then, when under detention, these kinds of workers actually reported that overcrowding in poor facilities, and they also had no contact with family or their lawyers as well. How serious are these situations when judged against U.S. law and international human rights standards?
It's a very interesting question. I looked it up. I was very, first of all, when you see the immigration law, right, some certain kind of law, legal field that consider as to like purely sovereignty issue, means that the other states normally do not talk about the immigration cases, because that if some country complain about some other country's immigration law, and they can do that whatever do, it's basically, whatever you want to do, you do it, right? You don't really making immigration stuff talking to other countries because that their own discretion. And so by nature, immigration law is not, it's more like considered as more like an independent, sovereignty issue on there by one state, by another. And second is that in some of the international human rights violation issues that I actually looked it up, actually, in most cases, and United Nations has like, the UN standard minimum rule for the treatment of the prisoners, right, specific, also called like Nelson Mandela rules, right, based, famous. But however, then what happened was that it's applied to prisoners. So it means that there's criminal violation happened. But in U.S. court looked as the civil violation, not criminal violation by itself, right? It could be something related crime happened in the meantime, but by itself, as they look at it as the criminal, not criminal, it's a civil matter. So that's very concerning because that the Supreme Court, U.S. Supreme Court looking at it as a purely civil matter. So the case that there's a lot of things, legal implication on these issues in the future.
Mm-hmm, mm-hmm. So now let's also touch upon how policy fixes would follow up. So beyond clarifying B1 business visitor visas for short stays for meetings, Professor Connolly, is there a realistic path to creating a new visa under the H-1B specialty worker visas for longer stays for skilled jobs so that technical teams can actually legally remain in the U.S. for months of training?
Right, and I think in theory it can be done. The US has these agreements with other countries, Canada, Mexico, Chile, Singapore, Australia. And currently, I think South Korea can make this argument through working groups with the United States. And there is even legislation that's currently been proposed, the Partner with Korea Act, that would create an allotment of 15,000 E4 visas for highly skilled Korean workers. So I think theoretically this could be done, but fundamentally is the problem of domestic US politics. And just like Attorney Ann talked about the problem of legal precedents, I think another problem right now is in American domestic politics. You have very strong stakeholders with very strong anti-immigration agendas that are becoming powerful forces in US politics. And even this Partner with Korea legislation, it's been introduced since around 2013 and it never gets anywhere. So with the anti-immigration agenda so strong today, I think it's even less likely to succeed. And let's remember Trump's One Big Beautiful Act. It basically created $170 billion of funding over 4 years for border control and kind of immigration deportation. So think about in the United States, there's this gigantic deportation industry being created in addition to the legal precedents that we just talked about that makes changing course very difficult at the political policymaking level.
So these facts are very important because, we are going to expect more trade investments, more business investments to the U.S. from South Korea from the latest trade deal, of course. So how might this unresolved visa issues actually affect future projects, trade talks, and supply chains as well?
Well, absolutely. And I think it operates on two levels. The first is like a chilling effect on Korean companies that are considering investments, and especially the smaller subcontractors that might not have the political clout or the financial ability to get the very rare, 2,000 Koreans get the B1 visas a year, or the business visas a year. So this means that smaller subcontractors are less likely to be willing to do this. And the second level it would operate is companies already active in the United States. By needing to be fully in compliance with the current US visa regime, it's going to cause costs and slow down work. And during the Biden administration, the Americans knew that the Koreans were maybe gaming the visa system quite a bit, but they didn't enforce it. But the Trump administration is now enforcing it. And if Korean companies want to follow the law, and in America today, the law is a very shifty object, it's going to mean they have to do things by the book, which will mean slower and less progress on a lot of these investments.
Right, so it could actually ripple far beyond Georgia into trade talks and future supply chains as well. Now, since this B1 visa rules are still quite unclear and open to different interpretations, Attorney An, what kind of legal guidance or some kind of a clarification do you think should Washington issue so that Korean engineers know exactly what activities are permitted when they actually travel there?
Yes, it's interesting because it might be a political question. It depends, right? And then, as the Professor Connery mentioned, that it's more like U.S. domestic politics is changing, and they are become more and more anti-immigration, right? So things that's I'm very concerned that even if the Korean government or Korean companies, conglomerates, complain to the U.S. government, let's give us more visa, H-1 visa, and type, or create new visa types, so for us to do work to finish our work, and unfortunately, I don't think it's going to happen. It's very difficult to things happen in that way because there's very strong movement against immigration, and things like they want money. So more like a buy America, right? Buy America, hire America. Basically, they don't want the foreigners working in U.S., right? They want to invest money in U.S. and they want to hire U.S. citizens, right? I think that's the really things behind the story. And then the visa. So I guess really we have to find out what Trump really wants for this situation. Does he really want the things done as he promised or as planned, or does he just only want to show up that we have this huge amount of investment promise made by Korea, Japan, many countries. That's why I make this country great again. Or he really want things done as he planned. That's two different stories. So I guess we wait to see what happens in the following months, is because that I'm sure the White House will take some action. And that depends on what kind of action they're taking. I guess we can see how serious they are. They want to try to keep their promise on their side in the United States. So if they want to do it, or they just want to get money and hire some Americans, right? So, and plus, if I want to comment, it's very interesting. I looked it up, the IC's official press release. I was very surprised to find that, the name of the project name, their raid on Hyundai factory, how they call it. Officially, they call it the Operation Low Battery. I was shocked to read that official name, how serious they are. They want to kill the company because there's a low battery. It's a battery company, and they officially call it low battery. I think that's really explain everything, that how they looking at the situation here. And we have to think very carefully what they're doing right now, because they are changed. They're a new America with new law. So we have to look at it from an angle. I think that's, that's like the comment.
For a clearer view of the situation, we would need to look into what President Trump actually ultimately wants, his goal. Now, so in relation to this, so if we look ahead after this crisis, then Professor Connolly, what kind of joint measures do you think should Washington and also Seoul put in place to prevent a repeat of this situation, so that Korean workers and companies can feel a little bit of security going forward?
Well, I think the solving the problem is straightforward if, as Attorney Han said, both sides want to solve it. I think for the Koreans, for over 10 years now, they've been saying we need more visas, we need a larger quota. If the U.S. policymakers think that this Make American Industry Great Again requires more Korean visas, the Trump administration could definitely get that done. We've seen them circumvent Congress a lot already. There are ways the administration could fudge some sort of agreement to facilitate it. And I think right now there's momentum to make a joint working group on this between U.S. and Korean authorities. And maybe from the Korean perspective, adding this to the current negotiations over the tariff deal could be a strategic way to maybe try to get some confirmation of the visa rules. But again, this is assuming that the U.S. is really seeking a win-win trading relationship with South Korea. If Trump's America First policy is really just a predatory approach towards its allies, then maybe the long-term strategy for South Korean businesses is de-risking some of their investments in the United States and maybe diversifying into other markets could be maybe give them more leverage in the long term over the United States than right now, where a lot of these Korean companies are very dependent on the U.S. market.
Right. So we'll really have to see what Washington's next moves would be, what measures they would announce in the coming months, and many allies would definitely will pay close attention to that. But as for now, we'll have to conclude our discussion right here. Thank you so much for your time and for your insights tonight, Attorney An.
Okay, thank you.
And Professor Connolly, we appreciate it.
Thank you.
And that'll be all from us on Within the Frame. Be sure to tune in again next time as we continue to explore the stories that matter. Till then, stay informed and engaged.